participants. So
welcome to the first in Shepherd and Wedderburn's second series of rural litigation webinars. My name is Elaine Brailsford and I'm joined by my colleague Stephanie Hepburn to talk about nuisance. Now that's nuisance in the legal sense as opposed to what might be referred to as a nuisance in everyday popular speech. No doubt tuning into this webinar to get your CPD points may be a nuisance, but it won't be a nuisance in the legal sense. In today's webinar, we will look at what may constitute a legal nuisance in the rural sector, both at common law and under statute. We'll also look at the court remedies and defences that might be available, and the penalties that could be imposed if a nuisance occurs. We'll also share some examples of cases involving nuisance that we've been involved in. Now, just a word of caution. Whilst the law of nuisance in Scotland and England shares the same basic rationale and common elements, there are differences between the jurisdictions. The scope of nuisance is much narrower in Scotland, and so English cases need to be treated with caution. So to start us off, Stephanie is going to explain what constitutes a legal nuisance.
Well, they can arise both under statute and under the common law. That is the law that's developed through case law over hundreds of years. The first mention of the term nuisance in Scots law was the case of Fleming against Ure in 1750, so we do go back a long way. Essentially what nuisance is interference with someone's enjoyment of their property through the actions of a neighbouring property. So the owner or occupier of a property must not use his land in such a way so as to disturb his neighbour's enjoyment of his property or cause damage to his neighbour's property. We can say then nuisance is really an instance of property ownership. The first definitive statement of the legal test that must be established is set out in the case of Watt against Jameson from 1954. And what that said was, in every case, the answer depends on consideration of fact and degree. The critical question is whether what he was exposed to was plu quam tolerable, when due weight has been given to all the surrounding circumstances of the offensive conduct and its effects. So there are two key aspects from that test that we have to look at further. What is plu quam tolerable, and what facts and circumstances are relevant? Plu quam tolerable means that the affected person must have suffered more than he could reasonably be expected to tolerate. It's not enough to just cause some mild discomfort. It includes damage to property in addition to serious disturbance and substantial discomfort. It's an objective test in the sense that reasonable tolerability is seen from the standpoint of the reasonable proprietor in the locality of the victim. So individual sensitivities to disturbance or peculiar sensitivities of the victim's operations will not render activity complained of nuisance if it wouldn't actually be nuisance to the ordinary reasonable occupier. So facts and circumstances then, a number of factors will be taken into account to balance the competing interests of neighbours. The first is the nature of the harm. In a lot of the historic case law, the nature of the harm is interference with amenity, but more recently we've seen the inclusion of claims for allegations of injury to health, diminution in letting or sales value, injury to public health, harmful effect on the salubrity of the neighbourhoods, and we've also seen a shift towards including complaints of physical damage to property. The impact and extent of nuisance is important. Just how intolerable is it? Material discomfort must go beyond the sentimental, trivial or speculative. So normal signs of life going on would not normally be actionable. The character of the locality of the nuisance is a factor as well. So smells may be more tolerable in the countryside than the city, whereas noise is perhaps more tolerable in urban areas. Time. Nuisance can have an impact because it's the time of day they take place, and as one case put it, a bell ringing in the middle of the night may be considered a nuisance, but it might not be so in the middle of the day. Frequency. Nuisance is usually a frequent or continuing wrong, so there's more than one act as opposed to just a one-off. Duration. Shorter occur, nuisances may be more tolerable than ones that persist for a longer period of time. Convention, so widespread practice or common usage, may mean nuisances is more tolerable. Importance: is the nuisance a result of an event that brings a community benefit? A balance must be struck between public and private interests, although the greater good argument wasn't sufficient to prevent nuisance from the construction of the stands for the Edinburgh military tattoo in order to cease. Avoidability: what steps can be taken to prevent the nuisance by a wrongdoer will be looked at. And lastly, protective measures: complainants should take reasonable measures to minimise disturbance, but they're not required to do more than conform to the ordinary habits of life. What about fault then? Does fault have to be established for there to be a nuisance? Well, it depends on the remedy that you're seeking. If you're looking for damages or compensation, then you must prove fault. Fault is either negligence or malicious conduct, that is, conduct in the knowledge that it will result in harm, or reckless conduct, so not having regard to whether conduct could cause harm or not. If you're looking for interdict or preventative remedy to stop the harm from occurring, then fault does not need to be established. And Elaine will now touch on the defences and remedies that may be available to a claim for nuisance.
Well, obviously, a damages claim can be defended on the basis that the necessary requirement of fault is not established. Similarly, that the alleged nuisance does not meet that plus quam tolerable test. Other defences that override a finding of nuisance might be statutory authorisation, prescription, that's time bar, and acquiescence. It's not a defence that the complainer came to the nuisance. Stephanie mentioned the case about noise from the construction of the stands at the Edinburgh military tattoo. This was still nuisance even although the tattoo had been taking place before the person bought her house in Ramsay Gardens. Similarly, in a case that Stephanie will refer to later, Mr and Mrs Chalmers against Diageo, the fact that the whisky distillery was there before the house in which the Chalmers lived was considered irrelevant. Statutory authorisation, well, what's that? The interplay between activities authorised by statute and the law of nuisance is actually very complicated. But in essence, statutory authority for an activity may afford a complete defence, where nuisance is an inevitable outcome, irrespective of the exercise of care and diligence applied, because you're carrying out the operation authorised by Parliament. Prescription now, well, it's not possible to acquire a prescriptive right to create a nuisance, so doing something for 20 years that creates a nuisance does not give you the right to create the nuisance, but you can lose the right to object to a nuisance if you do nothing about it for a period of 20 years. Then you decide you're going to object to it. The right may be lost in those circumstances by the operation of what we call negative prescription. For claims for damages, a nuisance can also be prescribed, but it's not settled as to whether the relevant period is 5 years or 20 years. Obligations relating to land are usually 20 years. Obligations to pay damages arising from delict is 5 years. Now, obviously, it's best to avoid any argument and make your claim within 5 years. Prescription does feature as a defence in the Chalmers-Diageo case, which Stephanie's going to refer to later. And the right to object to nuisance may also be lost where acquiescence is established. Now, for there to be acquiescence, it must be shown that the complainer had full knowledge not only of the existence of the activity complained of, but also that this would result in harm. So it's the harm, not just the conduct, that needs to be the subject of your acquiescence. And what about remedies? Well, remedies for common law nuisance. Firstly, there are the preventative measures. Interdict is the main one. Court proceedings can be raised for a declarator that the action complained of constitutes a nuisance, and on the back of that, for interdict preventing the action from recurring. Interim interdict is a measure designed to preserve the status quo or to prevent an imminent wrong until the state of facts has been ascertained by the court. So often you will immediately seek an interim interdict to stop the nuisance. The test, however, is a two-strand test and it's a high test. Before interim interdict will be granted, you have to show that you have a prima facie case, which means you have to establish that you have reasonable prospects of successfully proving your case. Then you also need to satisfy the court that the balance of convenience is in your favour, such that the interim interdict should be awarded. Now, to do this, you must establish that the order of interim interdict outweighs the inconvenience to the other side. The other preventative measure that you can take is that of specific implement or interim specific implement. For example, an order to remove something that's causing a nuisance. Now, that's a positive remedy to do something as opposed to interdict, which is to cease doing something, but the same considerations apply. But seeking interim orders is not without risk. Orders granted on an interim basis carry the risk that you will be liable in damages should the order not ultimately be made final. In that situation, that is if you're unsuccessful, the interim order will have been wrongfully sought and the pursuer will be liable for damages sustained by the defender in ceasing or removing as the case may be. We have a nice little Latin phrase for that which sounds a bit like a spell, periculo potentis. It means at your peril. So a degree of caution must be exercised before you rush off and seek interdict from some activity you believe constitutes nuisance. On the other hand, sometimes it's necessary to strike while the iron is hot, so to speak. If matters are left to continue, it may be harder to persuade a court either to remove something that's been there for a while or to argue that the status quo should be returned. The decision as to the appropriate remedy is always going to be dependent on the particular facts and circumstances. I imagine that concern about being liable in damages was no doubt why, in the case of Diageo, the Chalmers did not seek interdict. Can you imagine the damages claim they might face if they shut down the distillery? So we're now going to look at that case and some other cases on the common law nuisance, and Stephanie is going to deal with that.
Yes, so in the Chalmers against Diageo case that Elaine mentioned, this was a case brought under the common law of nuisance. Mr and Mrs Chalmers brought an action of damages. They wanted £40,000 against Diageo, who operated a whisky distillery, and they were claiming damage to their house and outdoor areas by the release of ethanol vapour, more commonly known as the angel's share. And what they said was that the angel's share evaporates and caused a black fungus to grow on their house and garden furniture. They sought diminution in value of their property and also cleaning costs, but not, as Elaine said, interdicts. The case went to a legal debate in 2017 and again last year on different points, and the judge took the opportunity to review the law of nuisance in Scotland. He found that evidence was required to establish whether or not the Plu Quam tolerable test was met. Diageo has sought to argue they had complied with regulatory requirements, and Elaine mentioned that as a potential defence. The judge found that the fact planning permission existed for a given use is of very limited relevance to the question of whether that use constitutes a private nuisance. The judge also helpfully confirmed there was no defence of coming to the nuisance. Prescription was also argued, and the defender was arguing the 20-year prescription test applied, and they had exercised the right to emit the vapours for a period in excess of 20 years. But the Chalmers said it wasn't the right to emit that was relevant, but the right to object that was the appropriate prescriptive test. And again, the judge said there had to be an inquiry into the facts before a determination could be made. There's not yet been a proof and evidential hearing on the facts, and it may be the matter has settled out of court. There was a second debate, as I said, on the extent of loss claimed, about £40,000, so it may not have been worth continuing. But if we do find out more, we will let you know. And our case is Sabbath against Fife Council and Milne, just from last year. and that case was about a property that was damaged by flooding from a nearby burn. An action was raised firstly against the local authority for a breach of duties under the Flood Risk Management Scotland Act 2009, and secondly against a neighbouring landowner in Nuisance. It was alleged that the accumulation of debris in a weir across a burn had the effect of blocking the burn and causing a flood, and that amounted to a legal nuisance. It was argued the owners of the weir were at fault in not maintaining the weir, in particular by failing to remove the accumulated debris. Based on case law that was put before the court, it was accepted that failing to remove debris is a relevant case in nuisance. As far as a breach of a statutory duty is concerned, insofar as there was a duty, the council were not in breach, so the court didn't have to consider whether a breach of a statutory duty could give rise to a private law cause of action. Similar to the Diageo case, this case went to a legal debate as well, and we're not yet sure if there's proof on the evidence yet, but again we'll let you know if that case comes out.
So turning now to statutory nuisance. Statutory nuisance has its basis in 19th century public health protection. It's designed to protect people, not property. Section 79(1) of the Environmental Protection Act 1990 lists the statutory nuisances, and we've put them there on the screen. As we've said before, the law of nuisance north and south of the border is different, and so section 79(1) is different depending on whether you're looking at the Scottish or the English provision. Now there is a very important distinction actually between section 79 being the English provision and that of the Scottish provision, and that can be found in the statutory nuisance of emitting dust, smell, steam or other efflua from industrial, trade or business premises. And this is because the English provisions define what is industrial, trade or business premises as excluding land used as arable, grazing, meadow or pasture, osier land, reed beds, woodland and land used for market gardens or nursery gardens and orchards, and land forming part of an agricultural unit. But this exclusion does not apply in Scotland. Now, in each of the cases listed, the matter must constitute a prejudice to health or be a nuisance. Prejudicial to health is defined as being injurious or likely to include injury to health. It's not sufficient that there's a risk to personal injury or accident. There must be an underlying threat to health from disease. So premises containing, say, a dangerous stair, that poses a risk of personal injury, that will not come within the scope of statutory nuisance, nor indeed would it come within scope of common law nuisance either. It might, of course, come under the law of occupier's liability, but that's a whole other topic for another day. So what is meant by nuisance in section 79(1)? Well, in the Scottish case, Robb against Dundee City Council in 2002, the majority decided that it sufficed that the adverse state of affairs were of such an impact that it would sustain an action in nuisance at common law. So nuisance in section 79 refers to a set of physical circumstances that are more than can be reasonably tolerated. So there's an overlap there with the common law. Fault. Well, importantly, when dealing with statutory nuisance, fault does not come into it. There's a defence of best practicable means, but the notion of culpa or fault does not feature at all in the legislative regime. So Stephanie will now touch on the defences and the remedies where there has been a statutory nuisance.
So depend on the type of nuisance occurring, it may be a defence to show that best practicable means were taken to prevent or counteract the effect of the nuisance, and that's under section 7 of the 1990 Act. The defence may be available for some of the statutory nuisances where the nuisance arises on industrial, trade or business premises, which, as we know, may in Scotland include agricultural premises. But in the case of fumes and gases emitted from private dwellings, the defence is not available. Looking at remedies, local authorities have got duty to inspect their area or to detect any nuisance and take steps to investigate complaints about statutory nuisances. Section 80 provides that when a local authority is satisfied that a statutory nuisance exists or is likely to occur or recur, the local authority shall serve an abatement notice. This can impose a number of requirements, so it can require the abatement of the nuisance, or prohibiting or restricting its occurrence or recurrence, and the works that may be necessary to achieve those purposes. You have 21 days to appeal an abatement notice. It's an offence not to comply with an abatement notice, and in that case, the local authority can serve a fixed penalty notice. If the nuisance relates to industrial, trade or business premises, the fixed penalty is £400, and in any other case, £150. Paying the fixed penalty avoids the possibility of a conviction. If payment is not made, the person committing the nuisance is liable to a fine not exceeding £5,000, together with a further fine equal to 1/10 of the level of the initial fine for each day on which the offence continues. If the offence is on industrial, trade or business premises, the fine shall not exceed £40,000. It's worth noting that under section 82 of the Act, a person may apply to the Sheriff Court on the ground he is aggrieved by the nuisance, so statutory nuisances are not always dealt with by abatement notices.
Sometimes a person can have a claim that falls into both statutory nuisance and common law nuisance. Take fumes emitted from premises, for example. If it's from a private house, that can be a statutory nuisance, if you can show that your health is affected. But common law, it could also cover from premises other than private dwelling houses, if you could show that the element of discomfort from fumes was affecting the enjoyment of your property. Would you choose to go down the statutory route or the common law nuisance route if you had a choice? Well, the problem with the statutory route is that it doesn't give compensation. It does pass the onus on to the authority to deal with the problem, however, saving you legal fees and avoiding the threat of damages if you're going to go for interim interdict or to have an abatement notice to stop the nuisance. But it does pass control to someone else, and immediacy is not always something associated with leaving things to the local authority.
So that's the law. Let's look at some examples of when this may occur in the rural sector. We've asked a number of people or colleagues what they perceive to be a nuisance in the countryside, and I'm going to go through a list of these, and Elaine will then discuss whether or not that may be a nuisance. So, the first is whether the smell from a neighbouring septic tank or private drainage system is a nuisance. Elaine?
Well, smell comes under section 79(1)(d) as a statutory nuisance if it arises from an industrial, trade or business premise. So if that includes in Scotland agricultural land, then it could come under that. So it very much depends where your septic tank is. It may also be actionable under common law if it can be established that the smell is beyond that which you could reasonably be expected to tolerate and it affects the enjoyment of your property. It might be said that smell of manure might come under section 79(1)(d), but I think that that's unlikely to affect health, and it's also probably unlikely to meet the tolerance test because that kind of goes with the countryside.
The normal smell in the countryside, yeah. Okay. So what if it's not the smell so much that bothers the neighbour, but a leaking septic tank?
Well, that's slightly different. That could be a statutory nuisance. If the leak seeps into the water supply, you could see that people could come into harm by that.
Yeah.
It could be prejudicial to their health and therefore actionable. But it could also be a common law nuisance because it affects your property. And again, the tolerance test will come into it. Of course, if it's a case of damaging your property, you also have your normal negligence ground as opposed to just nuisance.
So away from septic tanks then on to noise nuisance. Can noise be both statutory and common law nuisance?
Yes, it can. I've just settled a case on the door of the court
Last week
involving a hydro scheme, and our client claimed that that was causing noise nuisance. We had expert evidence that the noise produced by the hydropower turbine was tonal, and it was out of keeping in a rural setting, and it could be heard within our client's property. The increased noise from the turbine was in excess of 5 decibels, so that was considered to be a noise nuisance. Now, in my case, the defenders voluntarily attenuated the noise nuisance, but we still took decree to avoid it happening again. Now, we chose to do this under the common law because the action that we were raising was an action to deal with interference of other rights, not just nuisance. Actually, it was about riparian water rights. Puts another theme for another talk.
Unheard of concept in Scots law if we're used. So away from that sort of noise, what about a different kind of noise? Shooting. We have clients who are concerned about shooting on a nearby estate, perhaps close to a cottage or a residence on their estate.
Well, in the section 79(1)(g) in the list, I think that might be noise from premises. It obviously depends on fact and circumstance. You could argue that shooting noise might just be the normal sound of life in the countryside. It's not going to affect health. However, if the levels go beyond that which one might reasonably be expected to tolerate, you could have a statutory as well as a common law nuisance. I suppose it depends what time of the day it's happening. I think if you're hearing it at night, it might be something other than just countryside activity that's going on.
Who knows? So is that similar to noise from tractors then? It's a countryside noise.
Well, we had a case. We had a case where someone bought a farmhouse. It was on a working farm, and then they complained about the noise from tractors.
So they came to the nuisance.
Well, I would say they did. And arguably it wasn't nuisance at all. Normal sounds of the countryside. The combining was going on late at night, but again, I think our rural clients would tell us that there are times when harvest has to come in, and therefore you will work late at night. So the courts will take account of the time at which the noise is occurring. It's all part of the fact and circumstances and whether the noise is tolerable or not.
Away from noise then, what about animals?
Well, animals, they feature in that list there of section 79(1). 79(1)(f) defines a statutory nuisance as any animal kept in such a place or manner as to be prejudicial to health or a nuisance. An animal has a wide meaning. It includes poultry. The term kept is important. It's likely to imply a positive intent to keep an animal rather than just animals gaining access. And the animals don't have to be there permanently. This section has also been held to apply where animals are away from immediate control of their keeper. For instance, if they've strayed and caused nuisance to neighbours. That could well be a nuisance falling within section 79(1)(f). What's actionable just depends on the type of nuisance the animals are causing.
So would that apply to noisy animals then?
Well, it's not clear whether 79(1)(f) applies to noisy animals. 79(1)(g), that's noise emitting from premises. That might be more appropriate, I suppose.
Tolerability would come into it then.
That's true, yeah.
Smelly animals?
Well, actually, we had a case. We had a case where we were seeking to interdict a neighbouring landowner from duck rearing on the basis that the rearing of the ducks caused considerable nuisance, including noxious smell and noise that wasn't tolerable. And we were successful in obtaining an undertaking from the neighbour to avoid the need to go to court. And the rearing operation was relocated to further away from our client's land. So yes, actionable, and it depends really on the level of smell, etc., and the environmental conditions, etc.
So another concern that clients and colleagues have raised is professional dog walkers causing problems. What about them?
Well, as we've said, the owner of his land must not use it in such a way as to cause nuisance to a neighbour, but professional dog walking doesn't fall within that. What you have with professional dog walkers is probably more likely to be a breach of the right to roam. It might be said they're not exercising the right to roam responsibly. Yep.
I suppose sheep worrying is the same.
Yes, that's similar, because it's not using your land in a way that causes a nuisance to others. So, you're looking there at the Scottish Outdoor Access Code and the Dog Scotland Act and such like, Animal Scotland Act. Actually, we have a briefing note on the subject of sheep worrying. If anybody would like to read that, we're happy to put you in touch with that. And perhaps
comes up quite a bit, this one.
Yeah.
Couple of, just moving on then to water, a couple of, there's two to fully finish. The first one, allowing, which is based on a real life case I had up in Shetland, allowing the sluice gates on a dam on your property to become blocked, causing the dam to block and flood a neighbouring property.
Well, that's very similar, isn't it, to the facts in the Sabbath Fife Council case. And that may well be actionable. They obviously thought it was when they brought the case against Fife Council and Mr Milne. But to obtain damages, remember, you've got to show that the neighbours were at fault in allowing that sluice drain to become blocked.
In my case, Okay, just very lastly then, what about damp build-up to a neighbouring property being built very close to your property?
Well, perhaps not so prevalent in the rural sector, but I talked about a case I had last week. I've got a case going to court next week where we're trying to establish, amongst other things, that a neighbouring building has been built 3.5 inches away from our client's property, and we are claiming that that constitutes a legal nuisance on the basis that the narrow gap is going to cause a build-up of damp between the properties and could damage the wall of our client's property.
So much of the countryside then is now given over to a variety of renewable schemes. We've got wind farms, hydro schemes and biomass plants. I think from what we've covered, you can anticipate this may give rise to nuisance claims in the future, either at statute or at common law. Hopefully you'll not find yourself or your clients to be on the receiving end of either an abatement notice or an action for indirect or damages. Equally, we hope that today's webinar has given you a flavour, understanding of some of the issues that could be involved. We're just at time for questions, but we're happy to take some questions offline if that would assist. Our details are on the screen there. Equally, if anyone's keen to share some examples of current cases they have where their clients have perhaps been affected by things that may be a nuisance, be interested in hearing some shared examples. I think that concludes the webinar for today.
Thank you very much.
Thank you.